Can I have a thumbs up if we see the recording sign? Sweet. Hello to the folks at home. This is the last tutorial, the last substantive tutorial for Contract A. I was just saying to the peeps that are here in person, wowee, what a journey we've had. Gosh, a little bit of reflection. I mean, at the beginning here, you didn't know a term from a condition or a warranty, or that there was any difference between a condition or a warranty. You didn't know anything about, well, you may not have known much about the Australian consumer law, all of your rights that are available under that. You didn't know about the whole issue of construction of terms, probably that there was even a notion of construction of terms. This is all the hard yards that you've been putting in, peeps. You should be giving yourself a little virtual pat on the back here because you've come a long way. This is it's a big unit to cope with in your first year, and to get this far and to still be vaguely functional is awesome. I should know because I'm not vaguely functional. No, I am sometimes. And so please, before you start fretting about the exam, reflect a little bit on just how far you've come and the fact that, you can do this. You can do this exam. It is eminently doable. And as I was saying before, we shall do a little bit of exam prep at the end of this evening's tutorial just to kind of steer you in the right direction, because I know that there are a number of people who are starting to go away and prepare notes and all that kind of thing. So I'll give you a little bit of a preliminary heads up at the end of today. However, all of our substantive examination work, our real preparation will be next week. Now, thankfully, that comes, let us see, that will come quite some days. It's on the Tuesday, and is your exam on the Thursday or the Friday? I keep getting the Contract A and Contract B mixed up. Thursday? Amy and Megan say Thursday. So you've got still a couple of days between our final tutorial and the actual exam itself to more finely hone your preparation. Yep, Bill reckons it's Thursday also. Do check that. Again, probably the night before I would check Valentine's. Yeah, what's that? L'amour. It's CQ University. Check maybe the night before. I always did. Just call me maybe a pessimist, but you just want to avoid hassles with last minute changes. So do check that again. But as I said, we will do a few little things today, but really I guess the fine-tuning stuff I want to do on the Tuesday before, and just a lot of tips in relation to performance and actual technique. Okay, so I guess that's about all that we need to really say about that. The only other thing about administrative stuff that I wanted to talk about today was we need to start thinking about, we need to start perhaps writing up our tutorial participation reflection if you haven't already started that one. So please start thinking about that. It's only, 300 words or some such. It's very, very minimal. Have a look in the unit profile for further guidance on that piece of assessment. But essentially what I really need you to do is kind of sit back and reflect on your learning journey, as it were. Pardon me, I probably would suggest, and this is why I said to you, do keep popping into the Moodle forums and tapping out some ideas there, because then you can just go back and look at what you've written earlier on in the term and just see how you've progressed in your thinking, or what you learnt from that 1 week's worth of posts, of your post and other people's posts, my posts. What I'm really keen to see, and this is kind of what I opened up tonight with, was, your thoughts on your own personal learning journey. Everyone's learning journey is going to be different. Some points, that you have learned in this course perhaps were hammered home to you more than others. If so, just feel free to concentrate on that thing that really, you think was a bit of a linchpin in your understanding of a topic or an area, a 1 week's material. Things that you found useful, things that you might improve on, or perhaps take into another unit that you could do differently. All of that kind of thing I am looking for. So there's no one real recipe for this, and it does actually rather painfully, go figure, that's my dog, sorry. It does actually require you to sit down. Yeah, I know. I'll have to let him out in a minute. He's hungry. I will, you'll have to sit down and really think about one area. Hold on 1 second. Hey, the dog's here. Oh, it's fun and games. It's week 11. One area of law that you felt was really important in your learning journey, or even just one particular point in one area of law, or it might be a more general reflection on, the way that you feel you've progressed in your understanding over the totality of the course. I'm open to any of those approaches, but it does require an individual kind of effort, okay? So if you need any more help, let me know. Send me an email, but I think the unit profile is fairly self-explanatory. The other thing that you need to do before the end of next week is submit your quiz, your final quiz. Okay, so yes, William, there is a quiz as outlined in the unit profile in week 1. We have a final quiz. I think it's open already for entries. Yes, I've got people nodding heads. Ooh, I see organised people. That's awesome. Do go ahead and do that. Again, not scary. Something similar, perhaps just a tad meatier than your last quiz. Have your study guides, grown to say it, but there it is. Have your study guides at the ready. As I said to you for the first quiz, the same person that designed the first quiz is the person that designed the second quiz, and that is the person that designed the study guides. So I would recommend that you have them there to refer to for that second quiz. If there's any last minute issues, then please just, like I said, shoot me an email or whatever. They were helpful. Oh, that's good. Yes. So anything that you need from me, just let me know. I think this time of term is not the time of term to be a stranger, if you know what I mean. Even if you're not the kind of person that doesn't tend to email me or join in the chats on Facebook or join in the Moodle stuff, I think now is really the time to be super connected, because the more connected you are at this end of term, the better you will feel. And your performance at uni will be significantly influenced by how you feel. You can't help but have that be the case. And where you feel like you're in this together with a stack of, mates it's a much more, it's almost like suffering shared is suffering halved. You know what I mean? It's always, do we have a tutorial next week? Just, oh, yes, it is, you're right. It is just the 5th. It is just the 5th. So we have more than a week. I was thinking it was just a few days, but you're absolutely right, Caitlin. The last one will be the 5th of February. So you got oodles of time after next week to consolidate what we talk about next week. And dare I say it, start doing those wretched timed IRACs. You know, get in there, get your pen or pencil, get it all working, get the hand cramps going, get the bruises on your writing fingers, because as I've said before, it's quite, if you are used to typing, and I type at a decent pace, if you are used to typing, you will be quite shocked at how little you get done on the page when you transfer from typing an IRAC like we do in tutorials to, you know, writing one out old style. So try and do, yes, I know there's a few people worried about that. It's very old school. It's the best we got at this point. So I don't know what other options we'd have. Like I said before, maybe a chisel and some stone, a stone tablet. Take-home paper. We used to have take-home papers, but the accreditation board is forcing examinations onto us for at least the Priestley's, which is, you know, the contract cheating thing. They're trying to avoid that. Like I said to my contract B people last week, you know, it's never going to stamp out the contract cheating issue. And, you know, just because you stamp out the contract cheating issue, I mean, there's always other cheating that goes on anyway, in my view. I mean, I've invigilated in exams where people were, you know, people were actually giving their student card and asking their friends to do the exam for them, and I caught several people out doing that. I mean, cheating's cheating. People are always going to be inventive. I don't think you're ever going to stamp it out, but, you know, now we're stuck with handwritten exams for first-year papers. Yes, it does tend to ruin it for everyone that's doing the right thing. It's painful, but yeah, what can I say? No, we don't need to reference for the exam. No, we don't. Just case names is more than sufficient. Please do not waste time by giving me citations. You just need to be vomiting onto the paper everything substantively that you can at 2 words a minute with your pencil and eraser. Actually, no, please don't write in pencil, because I have had some left-handers write in pencil for me and then they just rub everything out as they go along. So all you get is just this big smear with nervous, sweaty hands. And it's not good. So, yeah, don't write in pencil. That's another tip. Anyway, let's get the substantive part of our tute done, and then we can kind of revert to a bit of exam chat, and then we'll do a big erasable biros. Oh, they do have those nowadays, don't they? You could try those. Oh, sweet. Tammy Lee's got her stationery organised. Officeworks. Nice. Yes, I've just done all of my kids' back to school shopping there. I should take out some shares in Officeworks, I think. In any event, letters. I shall pop my Documente on share. Okay. So this week we are looking at privity. It's a nice little, I don't know what you thought about privity, but I think it's a nice little area of law to end off with, even though it kind of seems to just be plopped in the end. I actually think it's pretty good to end off on, because, yeah, it's not terribly difficult to get your head around. There's not too many nooks and crannies, not a whole lot of difficult case law, and
really at the end of it, there's just a whole load of things that you need to be generally aware of, like, you know, the fact that you can try and get around privity with the likes of torts and with the likes of estoppel and unjust enrichment and restraints of trade and all that stuff, which we will cover in Contract B. So you don't really have to be too worried about that stuff. Or trusts. I know that for those people that like their study guides, I know that the study guide did go into trusts a bit, but I deliberately steer clear of that for the most part, because you go into trusts in detail in equity and trusts. So, you know, we don't really need to concern ourselves with those kinds of arguments too much here. So let us go into our tutorial on privity. The problem facts that we had in our little problem this week. Margaret and Alex have been dating for a few months. Margaret has to leave Brisbane, spend 6 weeks in London on a work assignment. While she's away, Alex decided to surprise her by remodelling her kitchen. Alex has a key to her flat, promises to check in and make it look like there's somebody home. Okay, fair enough. Alex made a contract with Steve, a kitchen designer and installer. Alex selected a colour and benchtop scheme and a range of appliances. Steve did the installation. Alex waited for Margaret to come home. Oh dear. Margaret then comes back and hates the colour scheme, hates the appliances, is rather appalled, and I probably would be too, actually, even if I liked the colour scheme, would be appalled that Alex would have taken it on himself to do all of this in her home. She dumps him. He changes his number and moves to Western Australia to work in the mines. Oh dear, worse was yet to come. She soon discovers that Steve did a poor job of the kitchen installation. The appliances didn't work correctly. The wet areas were not waterproof. She has no option but to get a competent kitchen tradesperson to repair the mess. She tries to sue Steve, but Steve refuses to talk to her. As far as he's concerned, he was hired by Alex, and the contract was completed when Alex signed a form saying he was satisfied with the work. Okay, now we are to here. Is that, I'm hoping, was the ACL your, Alex, I know, right? All these meddling people. Did the ACL kind of pass through your mind as you were reading this? And warranties of fitness for purpose and all of that stuff that we just finished talking about last week? I'm hoping somebody did. I'm hoping someone thought about that, because it really jumps out at you, doesn't it? I mean, obviously he's done a shoddy job, particularly where you see things like, you know, the wet areas weren't waterproof. I mean, that's a big fat red flag of, you know, quality and fitness for purpose. The appliances didn't work correctly. Well, obviously, if that had something to do with the way they were installed, then again, you're going to have issues there with fitness for purpose and so forth. But we get to ignore all that this week, and we get to have a look at the issue of privity. And we need to think about these two questions. Can she sue Steve for the cost of repairs? Could she do so if the events happened in a common law environment? Okay. So before we get going, as we normally do, can I just have a Y or an N? Let me just see how much backgrounding, you know, of material that people have had a chance. It's no real issue. It's just about how I pitch the tube. Oh my goodness. Oh my goodness. Oh my goodness. Look at all those yeses. Wow. Props to you people. Love it. Love it. You may well be my favourite class ever. Okay, so let's have a look at the doctrine of privity first. Can someone tell me in 25 words or less, no, it probably will be 25 words or less because it's fairly simple, what the doctrine of privity is all about, please?
Only a party to the contract may enforce the contract.
Nice. generally speaking, what is the more problematic bit of the doctrine of privity? Is it the bit about not being able to enforce benefits, or is it the bit about not being able to enforce the burdens? Does some part of the doctrine of privity make sense to you? Or does everyone just think it's a heap of rubbish? Or does no one actually care, given that it's week 11? Burdens. Under the doctrine of privity, third parties can't take advantage of provisions of the contract. Thanks, Deval. Yep, that's pretty much it. You were going with a heap of rubbish. I like honesty, Amy. I like it a lot. Jackson, oh, contentious there. I agree with privity. Others will set upon you, Jackson, with viciousness. Look, I think most people can kind of understand it's not really right that two people should just be able to get together and impose burdens on a third party. I mean, it just, you know, kind of accords with common sense, really. However, the bit that everyone seems to have a problem with is where two people get together and, you know, make a contractual promise for the benefit of a third party. Then, you know, some people will say, shouldn't that third party be able to enforce that promise? And, you know, one of the reasons why they say that you should not be able to enforce the promise is where this particular doctrine intersects with another doctrine that has a fairly close relationship. Can you tell me what I'm thinking of? Yes, Amy Lee, privity has been pretty much abrogated in Queensland. You're right. We'll get there. We'll get there. Steph! Woohoo! 10 points, Steph! Yes, consideration. A lot of people just think consideration does all of the work pretty much in privity. So why not just rely on the doctrine of privity? Particularly, what can you think of the 19th century, very early 19th century case that kind of would back up that kind of argument as to why it doesn't really make sense? Really, really early one. Trident, yeah. Trident has a lot. Oh, lovely Steph. You're on fire tonight, Steph. Tweddle and Atkinson, yes. Tweddle and Atkinson is the one that I was thinking of. Can anyone give me a 1 minute excursion into the wonders of Tweddle and Atkinson? I like this case just because I like saying the case name, Tweddle.
Is that the one with the people getting married?
Yes.
And the fathers were going to give money, but they died?
Yeah.
And then
I shouldn't be laughing, but the father-in-law dies.
yeah, and the guy who was going to get married tried to sue the estate for the money that the father. So even though it was the intention of the father that they should benefit from having the money, because he was still a stranger to the contract, he wasn't able to enforce, and there was no consideration from him to get the money.
Yes, exactly. And this was even so, despite the fact that both of the fathers had specifically agreed that the son and or son-in-law could sue to enforce payment. So there you have it. You know, the clear intention of the parties being circumvented by this doctrine that gets overlaid across everything. And clear bifurcation, there's a big word for a tutorial, in the basis for the decision there. So the thing that really kind of tends to, I guess, confuse people is that comment from Tweddle where they say he was a stranger to the consideration. And that almost seems to mix up the two concepts, doesn't it? Because technically, I guess if you're going to keep the doctrine of privity very nicely quarantined, you would say he was a stranger to the contract, there's your privity issue, and he had provided no consideration. And there is the consideration issue. Do you know what I mean? But because they had this nice kind of intermingling of concepts there, you know, people pretty much ever since then have thought, you know what, the doctrine of consideration could probably just do the job and you don't need to have this other doctrine hanging around. You decide for yourself, but I still got to say the word Tweddle. Okay, so that's Tweddle and Atkinson. I think, therefore, we all know roughly what the doctrine of privity is about. Amy Lee has already moved on in a very efficient manner, and we shall also do the same, to the fact that abrogation, the privity has been abrogated in Queensland pretty much. And our tutorial problem this evening is based in Brisbane. So we know that we are fairly and squarely within the realms of which legislation may or may not help Margaret out here. Yes, I know. Which is the legislation I'm thinking of? Woohoo! Property Law Act. Yes, Tammy Lee. Amy, that is correct. Mundo. Yes, Property Law Act is the one. So, and this was, you know, pretty groovy for the 70s. I mean, it was a fairly significant step to take. And one that I think, you know, I'm not sure how often Section 55 is relied on up here, but certainly I think the fact that it is there tends to allow the parties to negotiate around that fact, if you know what I mean. It's kind of in the shadows lurking, and people can kind of always point to it if they need to. I don't necessarily know that it gets a whole lot of litigation, because certainly in the legal sector anyway, everyone up here knows that, you know, that's the big provision from the Property Law Act you've got to know about so far as contracts are concerned. There are a few others, and you'll learn some of those in the Property Law Act in your property subject. It will also crop up in equity and trusts, that particular piece of legislation. So keep that legislation in mind. It's very, very useful. So the first thing we need to look at is, can Margaret sue Steve for the cost of repairs? So we have to ignore the ACL, which is kind of sad. And Section 55 of the PLA says a beneficiary can enforce a promise to do or refrain from doing, and it becomes enforceable on acceptance. What I wanted to do, I might just plop in the whole piece of this legislation. Did anybody actually, can I see who of the keen beans decided to actually go and have a look at this legislation? Did anybody go and have a look at it? Woohoo! I've had a few yeses. Nice work, people. Nice work. Oh, Lauren. Beneficiary means a person other than the promisor or promisee. Oh, yes, you're heading into beneficiary. We're not quite there yet, Lauren. Okay, so for those that haven't had a chance to look at the legislation, here it is here. So a promisor who, for valuable consideration moving from the promisee, promises to do or refrain from doing an act or acts for the benefit of a beneficiary shall, upon acceptance by the beneficiary, be subject to a duty enforceable by that beneficiary to perform that promise. So effectively, that does, as Amy Lee said, abrogate the doctrine of privity. up here. Where else does this legislation or equivalents of this legislation apply? Because it's certainly not right throughout Australia. Which are the lucky states and or territories? West Australia, yes. West Australia and Northern Territory, that's it. Yes, exactly. So there are only 3 of us who are the lucky ones. The other thing, and the legislation is roughly equivalent, as I said, in the other jurisdictions. What I want to draw your attention to is down here. Okay. The definitions of beneficiary and the definition of promise. Okay. Beneficiary means a person other than the promisor or promisee. Well, we know that because the beneficiary is what we'd normally think of as the third party. Includes a person who at the time of acceptance is identified and in existence, although they may not have been identified or in existence at the time the promise was given. Okay, so you've got to be able to identify the beneficiary at the time of acceptance. Okay. Now, here's the definition that's even more crucial for our little problem. Promise is a promise which is intended to be legally binding. Okay, no real problem there. And which creates or appears to be intended to create a duty enforceable by a beneficiary. Which creates or appears to be intended to create a duty enforceable by a beneficiary. So what's the big problem there for the odd, person that just wants to enforce a contract between 2 other people? The problem is that when you are construing the contract and this promise, which is said to work in the beneficiary's favour, you have to objectively, as we know, construe the contract. And from that objective construction, it has to be evident that there is a third-party beneficiary and that the promise is intended to be enforceable by them. So in your average 2-person contract, like between Alex and Steve, do they have to be named? We shall get to that, Amy Lee, we shall get to that. So that's the legislation that we need to work with. Okay, let's then go to our application here and note the salient issues. There has to be a promise, there has to be a beneficiary, and there has to be acceptance. And acceptance, so we've looked at the issue of beneficiary, we've looked at the issue of promise. In relation to acceptance, it just means assent by words or conduct communicated by or on behalf of the beneficiary to the promisor or the promisor's representative. Okay, so either the beneficiary or their agent has to communicate their assent to the promisor or their agent. So it doesn't necessarily have to be an assent communicated directly from the beneficiary to the promisor. The beneficiary can get their friend to tell the promisor's friend, if you know what I mean. I'm not quite sure why they allowed such a wide notion of acceptance, but there you have it. That's the way acceptance works. Okay, so we'll just go up here. See, an assent by words or conduct communicated by or on behalf of the beneficiary to the promisor or somebody authorised on their behalf. So it's a fairly wide notion of acceptance. So here, when we're thinking about, let me just flip back to the terms of this problem. Do you think that we have a beneficiary? A potential beneficiary? What do we know? Yeah, I know. Amy Lee's perplexed. Steph says no.
AJ, I don't know if I'm going to jump ahead of where you're actually going to go in a minute, but I think that because she had no idea, because it was meant to be, it's a surprise. Like she's completely clueless of what's going to happen. It makes me think of northern sandblasting in the High Court decision that came out of there, and it's related still to faulty appliances and even worse, personal injury, and they still said there was no beneficiary, even though they were aware of what was happening. So my guess would be she had no idea, and the outcome wasn't as bad, and she wasn't named, and, you know, all of these things, that she wouldn't be a beneficiary, and therefore privity would apply and couldn't sue.
Yes, and this is where I was trying to get to before. In the ordinary two-party contract kind of situation where you've got Alex contracting with this shoddy contractor, Steve, it's very unlikely, well, it's unlikely, number one, that you're going to have written terms, although if you do have written terms, because it's a two-party arrangement, and like you say, Margaret's just like completely out of the picture here. She's off over in London, poor person, and this whole deal has been done behind her back. So it seems quite unlikely, even if there was a written agreement, that she would have been named. And I even think, or hazard to venture, that this is not the kind of contract that would meet that definition of promise that we just looked at. Okay? Promise has to be intended to be legally binding. Well, we know there's no problem there, don't we? Because there has been a legally binding promise between Alex and Steve, hasn't there? Get Alex and Steve for trespassing. Ooh, no. Maybe you could try that on your tours. But please don't go that anywhere near trespassing in your contract exam. So we know that there's no issue in terms of the quality of the promise between Alex and Steve, because there's been a swap of promises, there's been that swap of consideration, hasn't there? So there's no problem with that limb of this definition. This is what I was getting at. This is where the northern sandblasting issue comes in. Okay? In conjunction with this part, okay, of the definition of beneficiary causes a problem. At the time of acceptance, the beneficiary has to be identified and in existence. Identified. Okay? And that is, it's this, and these reasons why I'm not sure I like privity. Doesn't seem fair. Yes. And that is why so many people and so many judges have advocated that you could probably just make do with the whole doctrine of consideration, really, although that probably wouldn't get Margaret too much further down the track in our case. And that's where your ACL is beautiful. Okay. Does seem a bit rough. Yeah, it does a bit. So, in terms of applying the law to our facts, we know what our guts tell us, but let's just dump in what we might say. So before I dump it in, where would you start in an IRAC on this question? Okay, and it might be a nice little question to just sit down and do a timed IRAC on, actually, because it's nice, simple, it's not too much case law to worry about. Where would you start? You know that your issue statement's got to be pretty easy peasy, isn't it? Because it's almost just the question itself, isn't it? And this is often what you can formulate your issue statement as. Okay, we know that privity is an issue, so you could always say, can Margaret sue Steve for the cost of repairs, or will the doctrine of privity prevent this? Or you could say, can Margaret sue Steve for the cost of repairs in light of Section 55 of the Property Law Act, Queensland, or something that just flags the privity issue. Do you know what I mean? And then in your rules section, you're just basically going to have Section 55 of the Property Law Act. You're going to have cases like, Northern Sandblasting and Jones and Bartlett. And then you move on to your application section, okay? So if we go, oh boy, I've got Contract B people coming already. Okay, so where would you start off in your application here? How would you kick it off? In my way of thinking, I think the simplest way to start unpacking it is just to go touch on the requirements of the legislation as I've done here underneath the heading of how does this all work, and then go into your actual application. So there's your law. And then I probably would be more specific there. Applying the legislation to the facts, it appears that there has been an otherwise legally enforceable promise made by Steve to Alex. No problem there. Alex and Steve gave and received consideration and could sue to enforce that particular contract. Now I've identified the benefit that you'd be looking to enforce here, okay? The relevant benefit would be the assurance of quality or standard of workmanship by Steve to Alex, okay? And then I've just stated the problem up front. The difficulty is that the promise may not satisfy the definition of promise in Section 55. 6 of the PLA. We are not given details of the contract, but there's nothing to indicate that it creates a duty enforceable by a beneficiary. Okay, if that is in fact the case, your promise is not going to satisfy the requirements of an enforceable promise under Section 55(6). And also, we've got that problem with her probably not being named as a beneficiary. Actually, here we go. Either as a person or as a part of an identifiable class. So if, for example, there was something in the contract that said that Steve and or his servants, agents and employees or some such thing, and she happened to fall within one of those classes of people, that would be sufficient identification for her, certainly after Trident, wouldn't it? So we've come up against those two problems, the definition of promise and the definition of beneficiary. So then we go into saying she's going to find it difficult to obtain the assistance of the Property Law Act in enforcing any warranties. Now, tell me what you would then lead in with. I think it was Amy Lee that said something about northern sandblasting, or is that Steph? No, it was Steph. So what would you then say to us about how would you unpack northern sandblasting for us in terms of these problems that we've identified with the legislation?
Well, I think because there was in northern sandblasting, it was the landlord who had done the repairs, who had contracted for the repairs. So It was, and the person who was injured was the third party.
Mm-hmm.
But because they were not named, they then weren't able to directly sue. And in that case, and in what you said before, Jones and Bartlett, the courts seem to be really, really strict and mostly unbudging on the fact that if you're not named, then you're not a beneficiary, and they're not. That's it. To try and, I guess, protect the doctrine of privity. So I would kind of go into that once you've gone through the legislation and all of that to say, was she named? No. The High Court or the court say that this is actually quite a big deal, and then that's what I would do.
Yes, and that was 5 stars, and I think the only qualification to that would be that perhaps instead of using the term named, although they do lapse into that, maybe try sticking to the term identifiable, because that's what we need to hunt out from the definition of beneficiary. Okay, they need to be identifiable and in existence, and that in conjunction with paragraph B of the definition here is what really creates that problem for Margaret, because as they said, Jones and Bartlett, there's without some indication objectively from the contract that it does actually appear to work in favour of a third party, then you've just got a two-party contract, haven't you? So you can't then use legislation to lay over the top of that and cut across what is the plain meaning of what the parties intended, because to do so would be twisting the legislation. Do you know what I mean? So you can't use it in a way that will solve problems for a third party beyond which were intended for the legislation.
Excuse me, AJ.
Mm.
I read in Wilmot there's a section and it's about agency. So I'm just not sure, because it talks about how, so if you've got party A and B and then party C can actually ratify the unauthorised conduct of party B. So if they went into a contract on their behalf without party C knowing, that they still actually will have a right to enforce the benefit. And I'm just wondering how you would go about saying whether, like, how he would, if he would qualify, Alex would qualify as an agent, like how do we sort of get around that part?
Yes. So let me just go down here. Are we all good on, I just want to make sure that everyone is all good with this problem that we would have under the legislation, and then we can kind of move on to the agency issue, because that's actually the next part of the tutorial questions.
Sorry.
But I understand why you're itching to get there, because you kind of do feel that she needs to have some remedy here. The difficulty with okay, so let me just pop in this last bit that I've got here for us. Okay. So at common law, the second question is, could she sue for the cost of the repairs if the events happened in a common law environment? We've already discussed Tweddle and Atkinson. Okay. Here is your agency argument. And I'm really super glad that you brought this up. Because yes, you can try and construct an agency argument, usually in conjunction with a collateral contract argument, as Dunlop did. But where you have the problem of an agent that's acting in within ostensible authority but beyond actual authority, which you can go back and retrospectively, you can ratify. Pardon me, it doesn't get you around what issue, and this is the issue that they cropped up against in Dunlop and Selfridge. Yeah. Consideration. Okay. There was no consideration. So in that case, remember, you had Dunlop asking Due, the company called Due and Co., not that saying they would sell the tyres to them if they promised not to undercut the list price, and then Due on selling and then getting Selfridge to promise Due that they wouldn't undercut the contract price, and then them going ahead and undercutting, and Dunlop trying to sue Selfridge, saying that Due and Co. in the middle was actually acting as their agent. The problem for Dunlop was that there was nothing that flowed directly from Dunlop to Selfridge. Okay, the only consideration in that circumstance was between Due and Selfridge. Due promised to sell the tyres to Selfridge. Selfridge promised to pay for the tyres and also promised not to undercut the list price. There was nothing in that undisclosed principal argument that showed that any consideration had flowed from Dunlop to Selfridge for the benefit of that promise that was made to Due. Does that make sense? So that is the problem that you're normally going to crop up against with that kind of thing. And I would dare say if Margaret now suddenly tried to shove $10 in Steve's wallet to give him some consideration and then retrospectively say, oh, Alex was my agent. Now I can sue you. I think Steve would probably, if he was smart, tend to refuse that $10, if you know what I mean. So Trident and McNeice did canvass a number of these arguments. Oh, that's the other thing I wanted to go through and just make sure that you understood, because there was this whole convoluted discussion about, all those shipping cases and the Himalaya clauses. I'm hoping that kind of, it is a bit complex. I'm hoping after you saw my vid, it made things a little clearer. The thing with Himalaya clauses is that they work by virtue of a combination of an agency argument and a collateral contract. Okay, so you say that in our situation, you would argue that Alex contracted as agent for Margaret, and then once Margaret provided consideration directly to Steve, a collateral contract would spring up between her and Steve, is the way that would run. So in a Himalaya clause, usually the carrier will contract with the owner of the goods that are being shipped to say, you're going to give me, the carrier, an indemnity. Oh, and by the way, I'm acting as agent in respect of this clause, this indemnity. I'm acting as agent for all of my servants, agents, employees, subcontractors, and so forth. And then once that subcontractor, which is usually a stevedore that's unloading the ship and drops stuff, bangs stuff, mucks things up, then they will want to claim under the indemnity between the owner of the goods and the carrier. And because they are named in that contract as one of the class of people that will be covered, the moment they provide consideration to the owner, they can enforce that little contractual provision that was bargained for their benefit. Okay, and some cases have found that the consideration would simply be the stevedore starting to unload the ship directly for the owner of the goods. That's sufficient then to enliven a collateral contract which springs up as a result of that initial little contract term that was bargained for on an agency basis. Okay, so you have almost like a two-step argument. You have the original contract between the owner of the goods and the carrier. The carrier says, I'm bargaining, at least in relation to this term, on my behalf and also for all of my little people. And there you have that, and that's your Himalaya clause. And then as soon as the stevedore unloads the ship, that's your consideration. And then a contract directly between the stevedore and the owner of the ship springs into existence, and that's your collateral contract part of the argument. Okay? Clear as mud? Beautiful. So collateral contracts, I don't think that they would work here. Remember Shanklin-Pierre, the Shanklin-Pierre case ran just a pure collateral contract argument where they said, well, you know, there was this, and it's something similar here, so I guess it would be useful to mention this in an application when you're doing an IRAC on this problem. It would be useful to mention the Shanklin-Pierre case, wouldn't it? Because you had implied warranties as fitness for purpose in that initial, in the contract between the maker of the defective paint and the painter that bought the paint. In that contract there was implied warranty of fitness for purpose. The problem was Shanklin-Pierre was standing out here in the cold, not a party to that contract there. And so that's where your collateral contract argument came into play, because it was Shanklin-Pierre that had discussed the quality of the paint with the paint producer and said, oh, okay, I think your paint's pretty good. I'm going to actually stipulate in my contract with the painter that they must buy your goods, your paint. And that was enough consideration flowing from Shanklin-Pierre directly to the maker of that defective paint to then enable a collateral contract to spring up that floated alongside the original contract that contained that implied warranty of fitness for purpose. Again, clear as mud. I'm hoping that it's not too complicated for you, because we have brushed up against this Shanklin-Pierre case and collateral contracts earlier on this term. So it's just another way of enforcing a promise that would otherwise not be enforceable. It's just a nice little judicial device, legal device that you can try and argue. So that's agency. What were the other ways that were discussed in Trident? What did Gaudron base her decision on? Anyone know? Oh, it's a bit of a hard question for the last 15 minutes of Tute. Leave us alone, AJ. We just want dinner. Yes! Nancy says trust. Yes, I want to talk about that in a second. Yes. We will cover unjust enrichment very fleetingly in Contract B. I don't go into it in any real depth, because since that decision, since Gaudron's decision, the whole area, the whole strength of force of the unjust enrichment argument has really been deflated. Unfortunately, subsequent decisions have denied that unjust enrichment is either a cause of action or a unifying theory in terms of restitutionary remedies. And that whole murky area of restitutionary remedies is just a dark cupboard that you never want to open unless you decide to do a PhD on the topic, because it's the stuff of nightmares. But it suffice to say, yeah, you don't need to know about that right now. Suffice to say, unjust enrichment now really is just a way to taxonomize a group of restitutionary remedies. It's not really even now considered to be a unifying theory, and it's certainly not a cause of action. There are some very specific elements that need to be met, and they are not, interestingly, they are not elements of cause of action. Unjust enrichment is not a cause of action. Okay, it is simply a way to explain why there's all these odd cases in restitutionary law that provide a remedy, okay, that wouldn't otherwise be available in contract. It's the stuff of, you know how the Matrix, you know, do I take the red pill? Do I take the blue pill? That's what restitutionary law is like. And so I don't think we really need to worry too much about Mary Gaudron less. Equitable estoppel we will cover next term. Not next term. Well, is the contract B even offered next term? I don't think it is. I think I'm on for term 2. See you then. Equitable estoppel we do to death in contract B, and I've just finished marking 60 assignments on it. So buckle up, peeps. You'll know it well. Trusts now. Somebody, Nancy, what would you like to tell us about trusts? Let me just cover that bit up. Did you want to say something about trusts here to try and avoid the doctrine of privity? No. Nancy's gone to sleep, as we should. Oh, hang on a second. Wait. It's just refreshed. Hang on. What's Nancy saying? Not really. Massive trust remediation in banking. Do you want to explain that? I mean, that sounds interesting.
We've got a whole heap of issues occurring at the moment that have come up at the Royal Commission regarding trusts and the way that they function in banking. So bank-wide, there's a mass remediation piece going on across all of CommBank to fix the mess that is trusts.
Yes. And trusts, you know, look, they are such a darn complicated area of law. Again, it's not something that we need to really think about in depth. And that's why I know that the study guide does go into constructive trust a little bit. But suffice to say, for our problem question, there's been no intention to create a trust here, has there? You could try on a constructive trust, but I can't see how that would get you too much further down the track. I don't think that there's an issue here of trusts coming into play. There's no restraint of trade here. Can anyone tell me what a restraint of trade is? Has anyone been subject to a restraint of trade? That would be a far more interesting question. Anyone tried to enforce a restraint of trade against you?
We were subject to a restraint of trade when we sold our business. We had a cafe, and when we sold it, we were restrained from opening another cafe within 30 kilometres and 5 years. Yes.
That is the typical circumstance where you will find a restraint, yes, in a sale of business. And did you comply? That's probably the even more interesting question.
Yes, because I wanted my weekends back.
Cafes are hard work, man. They are hard work. I have a lady across the road who owns a cafe. She leaves before I wake up and she gets home after I go to sleep. It's a very, very tough life. But interestingly, in a sale of business, generally, a court will tend to enforce a restraint of trade in a sale of business because they kind of, restraints of trade in other situations apart from sales of business, like where you try and restrain former employees from going to work for competitors and stuff like that, the courts will look much more strictly upon those sorts of restraints, and they will tend to enforce restraints that appear in a sale of business. So I'm glad to hear that you did comply because it probably would have been enforceable as a restraint. But we get to cover those in Contract B also. Yes. Yeah, look, restraints are really super common, and they are super common in employment agreements for lawyers. Go figure. Because there's a lot of poaching that goes on, obviously. But there's a knack to how you draft those things to be enforceable. And I think it was Duval that also mentioned torts might get you around the doctrine of privity also. So that is our difficulty. I don't think that there would be any common law way around the problem for Margaret in our particular circumstance. So that's where we're thrown back on the Australian consumer law, aren't we? Can we apply the same concept where a covenant was said to run with the land? Kitchen repairs could run with the land. That's some lateral thinking, Valentine. That is some lateral thinking. No, in a word. You can't transplant concepts like those that run with real property over to contract law, unfortunately. Might be convenient on the odd occasion, but it would make things really mucky. So no, generally we can't do that. Any queries? I hope we're all relatively comfortable with that. The big thing to take away is that after Trident, generally speaking, if you are able to identify someone as being the beneficiary as they were in that case, McNeice obviously was intended to be the beneficiary there. A court will do its darndest with one of many, many, many different ways to get around that doctrine of privity. Unfortunately, they won't always work. Seems like probably wouldn't work in this scenario. All righty, I will stop sharing. Let us quickly talk about the exam, because I know some people, we've got 5 minutes or so. And let's have a look at some broad areas that I think would be beneficial for you to look at. And the first thing, the structure, I want to go through with you. The exam has 2 parts, okay, part A and part B. And part A has 7 short answer questions. They all tend to have different marks. The highest mark is 4 marks and the lowest mark is 1 mark. So there's just a stack of little short answer questions. I don't expect you to go into much detail for those, particularly, for example, If there's a question that's worth 1 mark, don't give me half a page. It's really not worth your while. A few sentences at most, would be all that was required there. So 1 mark ranging up to 4 marks. They are a bit of a cook's tour of most areas of the substantive content of the course, including intention to create legal relations, capacity, acceptance. There's a little one on classification of terms. There's something on unfair terms, privity, and construction. So have a look at those areas. Yeah, the last one I mentioned was construction or uncertainty. So they're the areas that you probably would want to hone in on for those. In terms of the Part B, it consists of 2 questions, okay? 2 questions. Question 1 is a problem question. And that problem question is worth 15 marks. You need to do up an IRAC for that. Okay, so your IRAC is worth 15 marks. And question 2 is a choice of, you need to do 1 essay question. Okay, but you have a choice of 2. Please, 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 don't give me 2 essays. Oh, please don't do that. All right, so for Part B, what I want to see is your question 1 IRAC for 15 marks and 1 essay. That will be worth 10 marks. Okay, so Part B total is worth 25 marks. Part A, remember where I said we've got the short answer questions? Part A, the total of all of those marks is 15 marks. That brings you up to your 40 marks for this exam. Okay. I shall give you a little bit more guidance next week, but can I say in relation to the essay questions, have a look at the tutorial work that we've done this term, and that should steer you in good stead for the essay questions. In terms of the IRAC, I'll discuss that in a little bit more detail next week, but I would review the week 7 material that we did. Okay, so that brings us to 7:15. So that'll give you something to go on with. And in the meantime, ciao, ciao, and go and have some dinner, and I'll catch you next week. Bye. Bye. I shall end the recording.